SJC-12678, Commonwealth v. Jose Ramos.
Attorney Tomposki.
Good morning, members of the court. Michael Tomposki for Jose Ramos. The defendant is asking this court to reverse the decision of the lower court denying Mr. Ramos access to post-conviction DNA testing.
Yeah, counsel, can we assume for the purposes of argument for a moment that you check all the boxes and the test is done and it comes back and it is in fact the victim? What does that prove?
If it comes back as the defendant's DNA.
I'm sorry, the defendant's. What does that prove?
Certainly. I'm happy to get right to that point. So the question is whether that evidence would be material. Mm-hmm. And the Commonwealth concedes, it appears, that if it is material, a reasonable attorney would have sought to have it tested. So I'll focus my argument on the first point about whether it's material. And I want to start by addressing...
well, show me how it's material.
Certainly, yes, absolutely. So although there was strong evidence certainly as to the defendant's guilt, and we don't dispute that, the evidence was not undisputed. So the issue of what transpired between the two individuals inside the shelter prior to any of the staff being involved, and the issue of what transpired immediately upon their exit from the shelter was not clear.
All right, but we do know that there are two people involved, the defendant and this victim.
Yes.
And we have tape of some of it.
Yes.
And assuming it shows it's the defendant's DNA under the victim's fingernails, what does that do for you with regard to any of the defenses?
Absolutely. So what it does is it is additional evidence of a physical fight between the two that could have, based on the gaps in the video evidence, could have taken place prior to the stabbing.
But how would that get you beyond the issue of excessive use of force?
It may not.
Aha.
However, the Commonwealth has never argued, and the trial court never ruled, that a defense of manslaughter is not an available avenue to pursue a post-conviction DNA testing.
Okay, so how would the DNA under the fingernails get you to a manslaughter?
So the conviction being first-degree murder, our argument would be that evidence of a fight would be evidence of a potential manslaughter defense, in that the Commonwealth would now have to disprove either perhaps excessive force in self-defense or sudden combat.
Under the Commonwealth's theory, was there ever a fight?
The Commonwealth, well, was there a fight prior to the stabbing?
Right.
I don't believe the Commonwealth believes there was a fight prior to the stabbing, no.
So you're saying the potential DNA under the fingernails would show a physical altercation that we don't have other evidence of as it stands?
That's correct. So what we have, and just so to be clear, what we do have is we have evidence from the shelter employees that Ramos the defendant approached the employees and complained that the victim was antagonizing him, that he believed that the victim was drunk. And we have evidence from the defendant after the fact that he believed that the victim was usually armed with a weapon. We have evidence that the two men were in some sort of a dispute, a verbal dispute that day. They weren't getting along, and that they went outside for the purpose of fighting. That was the evidence at trial, and the very reasonable inferences that could be drawn from the evidence. They went outside to fight because you can't fight inside the shelter. Obviously, you would get kicked out. So they went outside to fight, and our argument would be that the presence of the defendant's DNA under the victim's fingernails would be material to the claim that they had engaged in a physical fight in the gap between, on the video, between the time they left the shelter and when the stabbing occurred.
Drill down to what you have to show. Do you have to show that the evidence from the fingernails would show that the victim was the first aggressor, or show that the victim at some point in time used deadly force?
We do not, in order to get access to post-conviction testing, it is our position, we do not need to show the victim used deadly force. that simply showing that there was,
Well, then how do you go past the argument that it was excessive use of self-defense?
our position is we don't need to, in the sense that if this evidence, the defendant's DNA being present under the victim's fingernails, would be enough perhaps to mitigate even a murder conviction down to a
That's the
manslaughter.
same question. That's the same question. So what is it about the evidence that would in any way demonstrate, so that the Commonwealth has to disprove that the victim actually was the first aggressor, or that the victim used deadly force?
I'm sorry, can you repeat the question,
Yeah,
please?
so you just said there has to be, it has to in some way help, in the light most favorable to the defendant, to get the manslaughter instruction, right?
To get a manslaughter verdict, yes.
Right, so, in that case, don't you have to show that this would have been some evidence that the victim initiated the violence, or that the victim was the first to use deadly force?
I think it would be, well, do we have to show that the victim was the first to use deadly force? No, I don't think we do. Do we have to show that there was some sort of physical altercation between the two, a non-deadly physical altercation before the deadly altercation? I suppose yes, and I think this would do that. If in fact the defendant's DNA were found under the victim's fingernails, it would provide evidence of a physical fight, a non-deadly physical fight, prior to the use of deadly force, which could have raised the defense of manslaughter.
You're trying to increase the mitigation evidence to try to get some type of sudden combat or heat of passion, correct?
That would be what this evidence could develop, would be a strong, and the defense of trial was self-defense.
Right.
That was,
But if you get hand-to-hand combat, you have more mitigation to work with.
that's exactly right. And that's what this DNA evidence could reveal, which is more evidence of mitigation, more evidence of physical
Let me ask you
combat
about
prior to the stabbing.
The next step then, how do you get DNA under your fingernails if someone punches someone?
Well, I don't know if this is in the record, but I'm happy to demonstrate how that might happen, grabbing on the arms or something like that.
But were there evidence of scratches?
I don't believe that there was, no, not that I recall from the record.
And that wasn't part of Judge Wilkins' decision, though, correct?
It didn't focus on that, no. I think
I
it
found it curious, but I didn't see it in the record.
yeah, no, I don't think there was any discussion of how the DNA might have gotten there. I think all parties perhaps were under the assumption, mistaken or not, that if there was a physical altercation that we could imagine.
But we
DNA.
don't know if there's DNA material under the fingernails. We just know they're fingernail clippings that weren't
We
tested.
don't know, right, exactly. We just know that the clippings were taken at the autopsy, they were preserved, and nobody tested them. So I think it's important, and the judge seemed to focus, a couple things. The judge, first of all, applied the wrong standard, and I think the Commonwealth even agrees that the judge applied the wrong standard, applied essentially an ineffective assistance of counsel constitutional standard, where the judge said, well, it came down to a strategic decision, and because it was strategic, you don't get post-conviction DNA testing. I think the Commonwealth concedes.
So I understand that the statute says reasonable attorney, and that's different necessarily
Yes.
than the Safarian test. But what exactly in that is different? I mean, how is a reasonable attorney judged as opposed to an attorney that made a tactical choice or something like that, which would be the Safarian? What's the difference between those
So
two
I
tests?
was trying to formulate that, actually, and I think what the Safarian test would say is that essentially every reasonable attorney should have followed the course that wasn't taken, and if every reasonable attorney should have followed one course and the trial attorney followed another course, that trial attorney was ineffective. In this case, the question is whether a reasonable attorney would follow the course to test the fingernail clippings. And I think another way to think about that is,
What's the difference between those two questions you just?
would it be, well, I think, would it be unreasonable to test the fingernail clippings, I guess, is how I would phrase it. And if the answer to that is no, then a reasonable attorney would have tested them. So it's sort of the inverse or converse, if you will.
On a mile-high level, we're fairly strict, or the courts are fairly strict at ineffective assistance, less so on post-conviction testing. It's completely opposite.
And this court's decisions have made very clear that it's to be read liberally with an eye towards granting testing if in close questions, that the results should favor the defendant. Because we're not asking for a new trial, we're simply asking for a test which could reveal evidence perhaps that would develop into a new trial motion, but that is obviously not where we are right now. And the court has said that even in cases where, and the Clark case said this, and the appeals court has said it also, even in cases where the evidence for the Commonwealth is overwhelming, the defendant could still be entitled to DNA testing if there would be some evidence that would develop on his behalf, potentially by the results. And of course, it's potential evidence. So the other thing that the judge said was, well, the DNA results might have come back with the defendant's DNA under the victim's fingernails, and they might not have. Well, of course, that's always true, and that's why the statute says it has the potential to. So we don't examine sort of the worst case scenario where nothing comes back at all. We look at what potentially could come back, and if there's potential for the defendant's DNA, then that would be enough. So the judge made a few errors in his analysis, the standard of review, the sort of potential, ignoring the language, the potential language in the statute. And so I think the Commonwealth points out correctly that perhaps, because this court's review is de novo, that wouldn't necessarily alone be grounds for reversal, but I think is an important lens to view the trial court's opinion with, which is that it seems to be a bit misguided. I would also just like to briefly address some of the claims that the Commonwealth has made. Particularly one, they say that the evidence was not material, that the potential for DNA under the victim's fingernails was not material, because even if, they say, even if the defendant's DNA was there, it might have been from a fight, or it might have been from some other time, and we don't know. Well, evidence doesn't lack materiality because there's competing inferences that could be drawn from it. Certainly the Commonwealth would be free to argue in their closing, if there was another trial, that the presence of the defendant's DNA under the victim's fingernails came from some other time, from some other circumstance, and the defense could argue that the DNA was placed there during the altercation, and the jury would sort it out. But the fact that there's competing inferences
that gets played out in the motion for new trial, though, because then you look to whether or not the new evidence would have impacted the jury, correct?
And that would be the standard at that time, whether essentially...
You're skipping a step. You get into a trial.
Perhaps I'm being overly optimistic, yes. But I guess my point is that the Commonwealth's argument that it's not relevant because a couple different things could be inferred from it is not what relevance means. Relevance means, could something be inferred that helps the party that's offering it, not is there only one inference that we can draw from the evidence. That's not the standard for materiality or relevance.
But, yeah, so that's my my question is, you seem to say that the evidence might be relevant, but isn't the test materiality?
And this court has never exactly said what the difference is between relevance and materiality, I don't think.
Well, relevance is broad.
It is.
Yeah, so you're suggesting that under this forensic testing, it is relevance, that the materiality is relevance?
I think that's a fair way to interpret the statute, that materiality is relevance. And I think relevance in the sense, perhaps it could be restricted a bit further, relevance in that it develops the specific defense that was raised at trial, not relevance in perhaps the broadest sense that word might be used for things that often are allowed in a trial that don't necessarily go directly to the critical issue. But relevant to the critical issue, the defendant's identity as the perpetrator of the first-degree murder in this case, I think materiality is nicely defined, neatly defined as simply relevant. The Commonwealth cites another case, a Brady case, and says that that's the standard. The court has never said that the Brady materiality standard is what controls for post-conviction DNA testing, and I would ask the court not to adopt the Brady test for these purposes, because that, again, that's more in the context of getting a new trial, not getting evidence that could or could not perhaps lead to a new trial, and the standard should be more relaxed in the context of 278A. If there are no further questions, I'll rest on my brief. Thank you.
Perfect timing. Okay, Attorney Baker. Hold on one second. Let's see if we can raise the volume a little bit.
Okay, thank you. I apologize for the delay. So I would like to address
viewpoint that came up on opposing counsel's argument. I'd like to begin by addressing the period to which he thinks the evidence is relevant, which is what he refers to as the gap in the evidence. As opposing counsel indicated, there was some of the fight that was caught on surveillance video, and then some of the fight that was observed by witnesses. Now, with regard to the surveillance video, there's video inside the homeless shelter in which the defendant and the victim can be seen leaving the shelter and walking through the hallway to exit. At that point, the victim is in front of the defendant, and you can see the defendant stop and allow the victim to go out first. As they then leave the building, there's surveillance footage in the parking lot in which you see the victim and the defendant walking. The defendant is about 10 feet, I would say, behind the victim at all times. And all of a sudden, he races towards the victim and he strikes the victim.
Mr. Baker, let me ask you, I read the closing argument, and the closing argument was that there was no fist fight at all, and this was an ambush, correct?
Right, so the argument was exactly that, was that.
All right, so let me ask.
They both parties left intending to fight.
Right, but,
The fight begins with this ambush, with this.
okay, that's the Commonwealth's theory. Let me ask you the question, though. So if they test the DNA under the fingernails and it turns out to be the defendant's, wouldn't that show some type of physical altercation, which would make the evidence different from what the Commonwealth posited?
I would say that it would not, and here's my reasoning, as came up when opposing counsel was arguing. It's hard to see how striking someone with your fist would result in DNA material under the fingernail. And when we usually find that kind of DNA material is actually in defensive maneuvers by someone. Say if I were to strike someone with my fist and then they were to grab onto that arm like so, then that material could be deposited under the fingernail. Now that's entirely consistent with no real fight from the victim.
Isn't that drawing too fine of a line in a case where we basically have all the presumptions go the defendant's way, and it's certainly nothing that Judge Wilkins considered?
I'm sorry, could you repeat that?
Right, that wasn't anything that the judge below considered, correct?
The judge considered that?
Did not.
Yes. Right, so let me say this about the judge, the motion judge, and his ruling. It's been argued that he applied the wrong standard, that he has applied the severity standard rather than the reasonably effective standard called for here. And Judge Cipher asked, well, what really is the difference between these two standards? And I would suggest it's very difficult to parse that out just based on how the standards themselves are articulated. And so you have to proceed inductively and look at what the case law has been when those standards have been applied. And with the reasonably effective standard, it has been applied in the way that the motion judge applied it, even though he articulated it differently. And I would call the court's attention here to Commonwealth versus Listen, that's a 2009 case out of this court, 483 Mass 27. And in that case, there was hair that had not been analyzed, and the motion judge had found that it wasn't relevant. And in that case, the court said that where evidence could be as inculpatory as exculpatory, a reasonable, effective attorney would not seek it. And again, there's Commonwealth versus Moffitt, which stands for the proposition that a reasonable, effective attorney does not have a duty to seek evidence that is not material. And so I think that the judge's finding that a reasonable, effective attorney would not have thought that evidence is correct, even though he articulated in terms of the fairness standard. If he had articulated it a little differently with the language that you would expect from a reasonable, effective attorney analysis, he would arrive at the same result. I also wanted to bring up the issue of the difference between materiality and relevance. And for that, I rely on Commonwealth versus Harwood. I cited in my brief on page 14. That says evidence is material if, in considering the entire record, it creates a reasonable doubt as to the defendant's guilt that is not otherwise exists. So that's a bit of a different standard than relevance. And then I also wanted to make the point that as far as the idea that evidence could be relevant when it is of different interpretations, well, that's certainly true. Or else a lot of evidence could be excluded as irrelevant. However, it has been said that when evidence has equally to sustain either inconsistent proposition, neither of them can be said to have been established by legitimate proof. And I would argue that that's a solid general standard epistemologic. That if you have two propositions which are contrary, and either of them would support your thesis.
That's not an you're citing, I think, to I think you might be referencing Commonwealth versus Rhodes, which is not an admissibility case. It's a sufficiency of the evidence case. As we're dealing here in the context of materiality, we're not dealing with sufficiency. So I'm not sure that case is really helpful.
I appreciate what you're saying. I would argue, though, that articulation of materiality, or, that it is generally that being said, again, I would simply fall back on the idea that either way that this analysis were to come out, it wouldn't be material to the issue that he wants to raise. It's clear from the evidence that that gap that he refers to, I mean, it's a clear inference that there was a fight that began immediately after the defendant struck the victim in the back. And the other thing is that the witnesses who viewed the fight, the rest of the fight, never saw the defendant strike the victim in the back. That's one point. And number two, the victim was wearing a jersey at the time that he was struck in the back, which he then took off before the part of the altercation that the witnesses saw. And the stab wound in the victim's back lines up with a tear in the jersey at exactly the same place. So there's very strong evidence that that strike to the victim in the back, that's called that camera, is the stabbing of the victim in the back. If Anthony is explaining video, you can't see whether there's a knife, but the inference that's almost inescapable here is that the victim was stabbed at that point. So anything after that the victim might have done in terms of the altercation is not enough to overcome the fact that the defendant is clearly established as the first aggressor and the first aggressor was using lethal force.
Attorney Baker?
Yeah.
Testing pursuant to 278A is supposed to be relatively easy to get.
Yeah.
So why shouldn't he have it? What's the why does the Commonwealth opposing this?
Well, I mean, in all candor, I really do oppose these motions. I agree. It is a very low standard. And I believe that we sort of hit rock bottom here, where there's the evidence is not material, then I feel I have an obligation under the statute to oppose it. But certainly, I agree, it's a very low standard. But it has to be material evidence. If you look at, for instance, Moffitt, in Moffitt, the question was whether or not DNA should have been done on some cigarettes that were recovered from the murder scene.
But here, but just no, I understand. But this is a little different though, because I mean, you in answer to a question from Justice Gaziano, you said, well, DNA under the fingernails is less likely, it's more likely to be defensive than to be something that where the victim was the first aggressor. But I mean, that's speculation, right? You argue that later. First, you find out whether there's DNA there to begin with, right?
So, well, that's the thing, though, is that even if it is present, even if there is DNA under the fingernail, I still don't think that is material evidence and goes to what the.
It contradicts your argument at trial that there was no fight, and it certainly isn't Moffitt. Moffitt was roadside trash.
But I don't agree that the trial prosecutor argued that there was no fight. It was clear there was.
Well, he argued there was clearly a confrontation. He argued, I'll check again, but my memory is he argued, or my notes say, there was no fist fight. There's no physical altercation. Clearly, there's an altercation. You have two people leaving the homeless shelter to go fight. And then the Commonwealth theory is one guy ambushes the other guy before the fight.
Right. Well, I would note that none of the others at any time suggest anything like a fist fight. There's a slight gap between that strength of that that's on surveillance and then the actual altercation that's observed. And nobody at any time is saying that this is a fist fight and then a knife comes out. What is claimed is that they're, to use the language the witnesses do, they're squaring off against each other, they're circling around each other like boxers before the defendant stabs the victim in the chest. Now, one witness claimed that before the stab to the chest, that the victim produced a screwdriver. Now, that was only one of the witnesses testified to that. That would have occurred after the strike to the back, which was, really a stab to the back. And so it wouldn't change the first aggressor analysis because it's not a matter of a fist fight that's been escalated by the introduction of a screwdriver.
I guess what we should go back to is the definition of materiality. And you referenced Howard, I think, Harwood, which is a case dealing with missing evidence and what the remedy should be. And Chief Justice Budd referenced that this is a low standard here. Why shouldn't materiality just mean that the evidence would be of consequence to the determination of the action and that it has some probative value for the defendant? And here, as Justice Gaziano referenced, well, it has some probative value to the defendant because it shows, inconsistent with the Commonwealth's closing, that there was physical contact.
I understand the point you're making is true. But I would just say that there's nothing in the evidence, so say that the DNA comes back and there's the defendant's DNA under the victim's fingernail. And that is enough to have an inference that there was physical contact between the two of them. That would only be physical contact in the sense of him touching the defendant with his hand, which would not escalate the situation where he's already been ambushed.
That's a great argument for a motion for new trial.
So even if he punched someone after being stabbed by them, I don't think it hits the defendant where he wants